Maybe the Lordship. Lordship, item number 3 and 4. I have already submitted the additional affidavit.
Okay.
But I think this is not tagged. So may call for this.
Okay, we'll call that.
And Lordship, this matter may be taken as the last item, Lordship, if possible.
Okay.
Lordship, highlights.
May I please, Your Lordship? Lordship, I beg to mention for listing of a bail application, the person is behind the bar since last 20 months, Lordship. On Monday, Lordship.
May I please, Lordship, I beg to mention for listing for withdrawal, Lordship.
Okay. When?
Mondays.
Obviously.
May I please, Your Lordship? Lordship, I beg to mention for listing on Monday, Lordship, bail application, Lordship.
May
May I please, Your Lordship? Lordship for listing one AB Monday.
Monday,
Second-
Tuesday. Tuesday? Listing. Monday or Tuesday? No, Monday we are all out. Tuesday. What do you say? Tuesday?
Number 1.
Motion.
May it please, Your Lordship. Your Lordship, item number 1 and 2 may be taken up together. Same
Okay.
matter,
Same
connected
matter.
matter. Item number 1 and 2, Your Lordship.
Quashing of proceedings.
Quashing of proceedings, Your Lordship. Your Lordship, in this instant matter, the same accused persons, 2 FIRs were registered on an interval of 5 days regarding the same cause of action, Your Lordship.
Mhm.
In item number 1, Your Lordship, the FIR is available at page number 14, Your Lordship.
Mhm.
May you please come to page number 14, Your Lordship.
Mhm.
May I read the FIR, Your Lordship?
Mhm.
I would like to inform that one 17 years old daughter, namely this, was forcefully married to a man named Ibadur Rahman, who is about 23 years old, son of Khalilur Rahman. This fact came to my knowledge through a reliable source. Later, I also got to know that she was forcefully married off to a man who is more than 11 years older than to her in lieu of the money which was offered to her parents. Further, she also informed me that the marriage took place in a traditional manner in presence of relatives and both the victims, girl and the groom. Therefore, I request you to take necessary legal action against the husband perpetrators. Given the fact that the child marriage is illegal and also the fact that she might become pregnant, I request you to register the case with the relevant provisions of law. Your Lordship, in this case, the informant is not connected to the victim in any manner, in any relative or any other capacity, Your Lordship. He is some stranger to the victim also. In this criminal petition...
No, I did not understand one thing. Two men, Ibadur Rahman, and then 11 years, but he's 23 years.
He's 23
No,
years.
no, Manat, she was 17 years.
And Ibadur Rahman at that time was 23 years old. Your Lordship. And this person who is the informant, he has mechanically filed an FIR in the outbreak of the child marriage crackdown, where he does not know the victim in person also. Your Lordship.
Anyway.
Here the victim is also a petitioner in the instant matter, wherein the victim herself has deposed that I have not got married before my age of being 17 or being a minor. At the date of FIR, her age is 17 years, 11 months, and there was no marriage solemnized on that particular date. Neither she was pregnant, neither she was having any child, Your Lordship. Therefore, Your Lordship, after an interval of 5 days, that is in item number 2, here in this instant case, they have the same informant has lodged another FIR dated 8th of February. The first FIR is 3rd of February, and the second FIR is 8th of February. Both the matters have been charge sheeted on 30th of March and 31st of March, and in FIR, may I read the FIR in item number 2 also, Your Lordship, page number 13. Page number 13, the FIR.
Of that matter.
Connected to the same cause of action, Your Lordship.
Informant is same.
Informant is same, Your Lordship. The parties are also same. The accused person is same. The father of the bride and the father of the groom, Your Lordship. May I read the FIR? Sir, I would like to inform you that one Mujibur Rahman has 17-year-old daughter, namely So, who was forcefully married to a man named Ibadur Rahman, son of Khalilur Rahman. The fact came to my knowledge when the girl was not seen with the family of the informant. Later, I also got to know that she was married off to a man in lieu of the money which was offered to her parents. Further, she also informed me that the marriage took place in a traditional manner in presence of both the relatives and families. Therefore, I request you to take necessary legal action against the husband perpetrator. Same thing, Your Lordship.
Same thing.
And in both the cases, the cause of action is also same. However, there is no strict proof that any kind of marriage has been solemnized. Neither she is pregnant on the date of the FIR, neither their parents have claimed that their daughter has been taken away by somebody else. He is a complete stranger.
I get. Lanka PS case number, what is the other one? 2 PS cases have been registered.
2 PS cases. One
but
is
not yet amalgamated.
Lanka PS case number 91 is one, Your Lordship.
91 by 2000.
By 2023, Your Lordship.
23.
Page 15, Manat.
Okay.
And
And this one is Lanka PS 119.
PS 119/2023, Your Lordship. Arising out of the same cause of action, Your Lordship.
What is the stage of the cases?
Your Lordship, at this stage, the case is fixed for appearance, and in annexure number
Then
4.
kindly tell me the PRC number also. PRC or special case number.
Special POCSO 66 of 2024. That is in connection to Lanka PS case number 91.
Special case number?
POCSO 66, special POCSO 66/2024. This is with regards to Lanka PS case number 91. And with regards to Lanka PS case number 119, the case is special POCSO case number 115/2023. These are the two simultaneous proceedings going on, Your Lordship. However, Your Lordship, in both these proceedings, NBW has been issued against the petitioner number 1 for his non-appearance. In item number 1, the case is the order of the NBW is at page number 29, Your Lordship.
In the first matter.
In the first matter, page number 29. Here, he has already submitted an absent petition saying that I'm out of station. I'm doing some menial task and as an employer in Kerala. May I given me another date to appear in person. However, that was rejected and an NBW was issued against this particular petitioner. Petitioner number 1, Your Lordship.
7126.
7126, Your Lordship. We are ready to cooperate and we are ready to face the trial, and also at this stage to determine whether two cases simultaneously function in regards to the same cause of action. That is why we have come before this court with regards to a criminal petition. May this NBWs be stayed at this moment, Your Lordship, and may I allowed to be participate in the trial, Your Lordship. The victim is also a petitioner in the incident, both the cases, Your Lordship.
Victim is Wahida Begum.
Indeed, Your Lordship.
Yes.
My lord. Here, first of all, it is the registered under POCSO Act, my lord. Here, then notice will have to go, my lord. First of all, my lord. Secondly, my lord, although it was in the order, it was reflected that, my lord, page 28, my lord, NBW was issued, my lord. First order is 26 to 2024, my lord. 24. Here, it was fixed for appearance, my lord. 3/6/2024.
I'm taking up the first matter.
First matter, my lord.
Page
28, my lord. 28,
28.
my lord.
Yeah, 36.
3/6/24 appearance, but thereafter order is 7/1/2026.
Long time.
For a long time they are absent. That's why NBW was issued, my lord.
Absent petition was filed, Your Lordship. Therefore, no, I did not annex all the orders, just I annexed the relevant
Absent
orders.
with steps. Anyway.
My lord.
Relevant orders.
At this stage, Lordship may call, we will have to verify the record, my lord.
Indeed, Your Lordship.
At that time, whether she was minor
You
or
can be
major.
asked to appear
Indeed.
by staying the NBW.
Indeed.
My
It
lord.
can be, otherwise he will not appear.
My lord.
Let the matter, because
But at this stage,
he's not seeking stay of the proceedings also.
My
And we are not, it is not necessary to stay the proceedings.
my lord.
He can appear and it can proceed.
Right.
In the meantime, we can
Right.
examine this.
Indeed.
Right? That will be okay.
Right. 15 days time may be granted, my lord, and he will appear and court below will consider, my lord, as per law, my lord.
Your Lordship, just
Third,
one
Mr.
difficulty, Your Lordship.
For learned counsel for the petition and learned additional PP. The state respond number 1. Full stop. Invoking the powers under section 528 BNSS, the petitioner's hearing, the 4 petitioners hearing are seeking quashing of criminal proceedings being special POCSO case number 66 of 2024 within bracket arising out of Lanka PS case number 91 of 2023. Under section, you would give write the sections, huh? So and so, so and so. And they give a dash. And pending before the court of the learned additional session judge Hojai at the stage of appearance. Full stop. It is submitted by the learned counsel for the petitioner that the FIR was lodged on P2/2023 by the respondent number 2 as informant, making allegations of child marriage with regard to the petitioner number 4 in this petition. Petitioner number 4 in this petition. But the facts of the case are denied, and that it is denied that any such child marriage took place, or that the girl was married off at all to the person concerned. It is further submitted that by the order dated 7/1/2026, NBWA was issued again, has been issued again.
No, it was earlier NBW was issued. On that they have filed one petition, my lord. That was rejected. Lordship here,
Fresh
Okay.
NBW.
my lord.
Okay.
Here it is said that
Okay.
আগতে NBW হয়ে গেছে।
Yes,
তো এখানে petition
okay.
করবে, reject করবে।
Fresh NBW.
No, absent with steps.
My lord.
Absent with steps.
Thereafter second para, my lord, Ibado absent with step 5 so showing cause petition here rejected.
File
NBW
order
issued
dated
against
se-
him.
Say, right, you're right. 7/1/2026.
Has not returned it. Right.
The petition filed before the learned trial court by the petitioner number 1 herein. Who's the main accused, seeking representation through advocate on that day was rejected. Full stop. NBWA is pending with regard to the said petitioner number 1. Full stop. Notice, steps of notice shall be taken. Copies may be furnished to the prosecution, and steps of notice shall be taken upon respond number 2 to the office of the learned public prosecutor, Assam, and to be executed through the concerned police station. It is submitted and undertaken on behalf of the petitioner number 1 that he shall appear before the learned trial court and desires to participate in the proceedings, and that earlier he was in Kerala with regard to some occupational activities. Also call for the scan TCR of so and so. On the court below, ho jaye, special judge ho jaye. I've given my consideration to the matter. Also heard the learned additional petition. The execution of the NBWA issued against the petitioner number 1, Ibadur Rahman. Right? We don't know the order, right? We don't know the
126. Issue fresh NBW later.
on 7/1/26.
7/1. Issue fresh, then therefore it will
Yes.
count as fresh NBW.
By order dated 7/1/2026 shall remain state, subject to the conditions that the said petitioner Ibadur Rahman shall appear before the learned trial court on the next and subsequent dates, and he shall not hamper or tamper with evidence.
Deeply offensive.
This is one. The second one will be broadly same, but we have to write one extra line. That it is submitted, that order of NBW is the same, 7/1.
7th one.
So here is the NBW. Oh, yeah.
Same.
Ibadur Rahman.
Same.
So only against Ibadur Rahman.
Only against Ibadur.
Petitioner number 2
Petition number 1, your lordship.
here.
One.
Oh, Ibadur, same person.
Same person.
Same persons. So the
But
same Ibadur.
FIR number is different, but
Oh.
case number is
One line you have to write extra, maybe. It is submitted by the learned counsel for the petitioner that this FIR has been lodged on with almost identical allegations with regard to which Lanka PS case number 91 of 2023 has already been registered, and investigation of which after filing of charge sheet has led to registration of special case number 66 of 2020. Others will be seen.
Let's here page 29, my lord. It was clearly mentioned, my lord. In the second case, my lord, perusal of the case record reveals that accused Ibadur Rahman was absent on previous many dates.
Yes,
That's why, my lord.
that is right.
Alright.
That is right. Others will be seen. Check it once. This is the matter on after, no, since notice is being issued,
Oh, my lord.
some time will be.
Your lordship, the
4 weeks.
conditions of bail would not be necessary, your lordship.
Huh?
The conditions of bail on appearance, your lordship.
Yeah, it will be the same conditions, the conditions of
Conditions
bail.
of the bail.
It's stupid. No, we are just staying it.
Staying the NBW.
Only staying the NBW. That's all.
Only
Sure.
recall, recall the NBW order.
You can file an application for bail
Bail.
there.
Deeply obliged.
Should I make an observation that it will be open to the trial court to recall the NBW?
No, my lord, here, Lordship already passed
Or
the order,
is it
my lord.
okay?
Here, they filed their praise bill for consideration, my lord.
Okay.
And the court bill will consider as the stay is there, my lord.
Okay. So this is because
Right.
suppose the trial court wants to recall the NBW and give them bail. So in that case, it will be handicapped because we have just stayed it. Said
My
nothing
lord,
else.
as it is already stated, my lord,
Uh,
they approach before the court below for regular bail.
Okay.
And the court below, after proper bail,
I'll make
visit-
an observation to that.
Right.
It will be open to the petitioners, right? That's okay. To submit an application for press bail for the learned trial court.
And the court below will consider as per.
Whereupon the learned court below would be at liberty to pass necessary orders, needless to say in accordance with law.
My lord.
Deeply.
My lord.
Take the date, please. Take the date. List after 4 weeks on. Take the date. 13th May. 13/5.
My lord.
Deeply obliged.
May I please, your lordship? Is that
Yes,
matter,
Mr. Ahmed.
lordship, where lordship, the property involved is lordship 4 numbers of solar panel.
Okay.
Page number 14 is the FIR. Primarily, lordship, I am on the length of detention, 2 days, 20 days, and as well as lordship gravity of offense. Page number 14.
Yes. Solar, the e-rickshaw, no? That one. No. Solar panels expected to have been arrested. Task. Yes, yes. Diary has come.
My lord, there is.
My lord, may I kindly come to the third paragraph,
Oh, page 14.
page 14.
Okay.
Number 1, Suksan Ali. Number 2, Rubullah Sheikh. That number 2 is the present petitioner.
Mm.
They were carrying 4 solar panels inside of the e-rickshaw.
Mm.
At the time of the detention of the said persons and the vehicle, a huge crowd gathered at that place of occurrence. Hence, all the persons along with e-rickshaw and the suspected stolen article, including the driver, were immediately brought to the police station. Upon questioning, it came to the light that above mentioned individuals, namely so-and-so, confessed that they had stolen the articles from Baihata Sariali with the help of another person, Rakib. Accordingly, lordship, they were arrested and case was registered under section 303, subsection 2.
Mhm.
On the last
They were arrested on 16/3.
16th,
16th.
lordship. Today's 20 days. 20. On the last occasion, lordship, I argued on 303, subsection 2.
Mm.
The punishment subsection 2. Whoever commits theft shall be punished with of either description for a term which may extend to 3 years, or here lordship or is there, or with fine, or with both. And in case of second or subsequent conviction, this is not relevant in the present case, and there is a proviso, provided that in case of theft where the value of the stolen property is less than 5,000, a person is convicted for first time shall return of the value of property or restoration of the stolen property shall be punished with community service. Here, lordship, without going to the other part of the case, my submission is
303 part.
Subsection.
subsection 2, my lord.
Yes. BNS, right?
BNS.
303
May I please read?
subsection.
Subsection 2, lordship. Punishment of theft.
Okay, punishment. Okay. Okay. Provided that.
Whoever commits theft shall, my lord, got it,
Mhm. Mhm.
shall be punished with imprisonment of
Yes,
either
yes, yes.
description for
Uh,
term which may
There's the
extend-
theft. Earlier 379.
Yes, yes, lordship. Earlier 379. Only addition is lordship, one proviso. This
Hmm.
is new. provided that in case of theft where the value of stolen property
Community
is less-
service.
Yes, Lordship.
It is returned.
I'm arguing that my the solar property which is involved in this,
But
they
it
are
would be,
less than.
value would be, I think, more than
Yes,
My lord,
I'm not arguing on that, Lordship. Just I have referred this, Lordship.
5,000 rupees likely that
Yes.
will be made more.
Yes, definitely, Lordship. For solar panels, perhaps, Lordship, it would be more than 5,000. I'm not on that. Just, Lordship, I have argued on that just to make my point, the gravity of offense, Lordship. This is the first time, even if we admit that the petitioner has committed that offense, he has already undergone 20 days. And another part, which is most important in this case, Lordship.
It means, what is this proviso? Basically, it's trying to, take a liberal view with regard to
Yes, Lordship.
first time petty thefts.
Yes,
petty
First
theft,
time
my lord, no.
petty theft.
Yes, Lordship. Yes, Lordship.
Where it
The
is
petty
less
theft-
than 5.
Less than 5,000.
Amount.
And
Petty
first-
theft again, what kind of, it also depends
Yes, Lordship.
on the value of a property, to a particular person, owner. It also depends on his economic condition.
Yes.
For example, a small mobile,
Mobile, my lord.
a cheap mobile for someone, but for someone it may be,
It may be that
he somehow managed to buy it.
By
Got it.
So something of that sort. But it has made an absolute amount also,
Right.
5,000,
Yes,
below
yes,
5,000.
Lordship. I'm not on that, Lordship. Just
Anyway,
Lordship, I'm
I get
trying
your
to make
point.
yes. And another part is that, Lordship, which is very important in this present case, Lordship. Here the word is involved, Lordship, either return or restoration. My submission is that, Lordship, 4 solar panels have already been recovered by the police on the very same day. And, Lordship, there is no other co-accused person who are to be arrested. And from the date of arrest, Lordship, I'm there in custody. They have not sought for any remand also.
Police remand? No.
No. So I'm in the custody. 20 days already gone, Lordship. So any condition, my humble prayer is that, Lordship may kindly allow me to go on bail.
Okay. Get it.
And I will be more careful, Lordship.
my lord,
Achha.
here,
Yes.
my lord, here we have received the case diary, my lord. From the case diary, it reveals that 3 persons involved in stealing the, my lord, from solar, my lord, from Bahata side, my lord.
Mm.
One is yet to be arrested, my lord, Rakib, my lord.
Mm.
Rakib is yet to be arrested, my lord, and present petitioner Suksan Ali and Robullah. Robullah Sheikh is the present petitioner. Both of them arrested, my lord. From their possession, it was recovered, my lord.
Mm.
When they are carrying this, sold it in a rickshaw,
Involvement
rickshaw.
of the third person has been found on the basis of investigation.
My lord, all of them, my lord. And from the statement of the, my lord, accused and co-accused, Lordship, one important thing is that, my lord, wife of present petitioner, my lord, she also stated that পেনেল কাৰ্টুন আমি ভাড়া ঘৰ ৰাখোঁ, মোৰ স্বামী আৰু সুকচান পেনেল বিক্ৰী কৰা মোক জনাই, ইয়াৰ পূৰ্বেও মোৰ স্বামীয়ে এনেকুৱা বহুত কাৰ্টুন আনি আমাৰ ঘৰত ৰাখে। That is the statement of the wife of the, my lord, present petitioner, my lord. In the earlier occasion also, there are some stolen property was kept in the house of the, my lord, present petitioner, my lord. That is also there, my lord.
Any other case? No.
Not
Not yet. Mm.
my lord.
No complaint was lost probably.
My lord,
Bapam, it was allegedly stolen from
Bahata side.
Bahata some depot.
No, my lord, it was kept in a place, my lord,
For construction site.
for my lord,
Construction site.
for installation, my lord.
CDR analysis is on.
My lord, on. Not yet received, my lord.
Let me see.
And interestingly, they have stolen 6, my lord, 6 panel, my lord. 2 already sold for 20,000 rupees, my
The
lord.
solar panels are costly.
Oh, costly, my lord. They sold 2 for
Solar
20
electricity is cheap,
2,000,
but installation is costly.
my lord.
Setup is costly.
My lord. They have sold two panel, my lord, for 20,000, my lord. And 4 remains, my lord, that was seized by the policeman.
Yeah, Lordship, the panels are also costly, Lordship. I have checked it online, Lordship. It
Yes,
is
sir.
definitely more
It
than
is- no,
10,000 per panel.
I've also
Lordship.
seen in court
Yes,
Mine.
I'm
installing.
saying,
It's it is expensive.
What
Project
are
is
the
expensive, but
quantity?
once you install, like electric vehicle,
yes, Lordship.
it's expensive, but running is cheaper.
It depends on the size, Lordship.
Mm.
But the most smallest one is also, Lordship, more than 10,000.
It is costly. As I said, no, it's like
Some IO objection is also there, my lord.
I see.
Right.
So maybe.
Apart from that, Lordship, already 20 days, Lordship, even the provision of fine, only fine is also there if I plead. Lordship.
Uh,
That is the only consideration.
in my
this case.
humble opinion, this may not come because it is in all probability be more than, actually they have not returned.
Right.
It was seized from them.
Yes, Lordship. And it is, Lordship, in the section it said written as, Lordship, either return or restoration. So restoration by the police. Upon return or restoration.
Well,
So
they're carrying,
I'm not going on those technicalities.
they're
Lordship.
carrying for
Only-
self, my lord, as per their statement also, my lord.
Appears to be regarding sentence.
My lord.
Yes,
If you
Lordship.
see it carefully,
My lord.
it just appears to be he's convicted, but at the time of sentencing,
Yes,
it's
Lordship.
not really a separate offense, it seems. The theft value, he is prosecuted for theft, suppose. Value of property is less than 5,000. He's convicted. Conviction is found to be first time, and the property has been restored or found or returned back by
My
him.
lord.
Then for sentencing, he
Yes,
should not be sent to jail.
My lord.
That is, I think. Anyway, because I think Mr. Ahmed should be
This is the
on
first time,
merits.
Lordship,
I
that
find it a little difficult.
But in the, from
Consider,
the,
Lordship, that,
Where is the bail objection?
my lord, in the initial page, one,
Yes, they make their contentions in the bail objection. Forwarding. Anyways. Third,
Lordship got bail objections.
yes, it's
Oh,
there.
my lord. From the wife's statement, it reveals that earlier also they have kept, my lord.
Why?
He said it innocently. Invoking 483 DNS, the petitioner, namely so and so, is hereby seeking regular bail in connection with Hathigaon PS case number 49 of 2026 under sections so and so. He was arrested on 16/3/2026 in connection with this case. The FIR was also lodged on 16/3/26 by ASI Pankaj Talukdar of Hathigaon PS. With the allegation that information was received regarding some miscreants, moving in the area for stealing solar panels. And accordingly, they proceeded to the area and noticed 4 persons in an e-rickshaw carrying some solar panels. Full stop. That comma, on being stopped, they were identified as Suksan Ali and Rabullah Sheikh, but they could not provide proper explanations for the items. And upon being questioned, it came to light that these had been stolen from Bayata Sarele and were being brought for selling. Full stop. The learned counsel for the petitioner submits that the petitioner has been in custody for more than 20 days. Semicolon, that comma. The solar panels have already been recovered. And that granting of bail at this stage may not prejudice investigation. The learned counsel has also drawn attention to the proviso to section 303, subsection 2, BNS, which it states that in cases of theft where theft of property value less than rupees 5,000, and upon first conviction and return of the property, return/restoration of the property, the accused shall be punished only with community service. Stop. The learned counsel submits that in the facts of this case, perhaps the spirit of that provision may be applied vis-a-vis the question of bail. The case diary has been received. The learned additional PP opposing the bail submits that sufficient materials have been found about involvement of the accused person, the accused petitioner in the stealing of the solar panels from Gauhati serial, and that the value of the, it is a full stop. It is submitted that during investigation, involvement of other person has also been found and he is yet to be apprehended. Full stop. It is also, it is submitted by the prosecution that it has emerged from the statements of witnesses that earlier also the petitioner had kept significant quantity of solar panels in his house. Full stop. The IO has also objected to the grant of bail at this stage. Peruse the relevant portions of the case diary, including the portions pointed out by the learned, by the prosecution. Full stop. The CDR analysis is also stated to be awaited. Full stop. It is stated in the case diary that upon investigation, no satisfactory explanation could be elicited from the accused persons regarding possession of the said solar panels. It is submitted with the prosecution that the value of the solar panels will be considerably more than rupees 5,000. There are indications in the case diary from the investigation that the petitioner along with others might have been involved in this kind of illegal activities earlier also. Full stop. And that same aspect is also under investigation as well. In the entire facts and circumstances, I am of the considered view that perhaps it may not be prudent to grant bail at this stage. And accordingly, the bail petition stands rejected, returned back at this stage. At this stage, return back the case diary. Disposed of.
Right.
High level.
Sometimes let's see. It will really harm.
Wait, please, my lord. My lord, this is a criminal petition filed under section 528 of the BNSS. So here we have challenged an order passed by the additional district judge of Borpeta, wherein our appeal was admitted and a condition was given of 20% payment of compensation. Appeal was admitted and a stay was given over the punishment, over the sentence.
In terms of 148.
In terms of 148. So we have not challenged the stay, but we have challenged the 20% compensation part. So, Lordship, the impugn order.
Both the matters are same. Is it same?
Same, yes. Same, and both the impugn orders are also copy paste.
I mean, both the two different checks.
Two different checks.
Two different proceedings.
No, petitioners are same here.
Yeah.
The complainants are different, wife and husband, Lordship.
Oh.
They are wife and husband. But order is same. Consideration for the order is same, Lordship.
Yes.
Grounds for same.
Two convictions, two appeals, and 20%.
Yes, yes.
The amount is 3,15,000 was the amount of compensation, and 3 lakh they are likely to pay most probably, if I'm not wrong. 20%, 3 lakhs.
Yes.
Yes, they have to pay 3 lakhs each, that is 6 lakhs.
Impugn order is at page 74.
Page 74.
See, the thing is that whatever little I know, this after this provision was inserted, there was this judgment, I think some Gandhi, no? That,
Lordship,
and thereafter there are some more decisions have come.
yes, yes, yes.
So
The
the
earlier
thing is
view-
that
yes.
thing is that these are aspects that we have to see that whether it is mandatory and up to 20%, not
Yes.
less than 20%. And if it is not mandatory, what is the nature of the discretion and whether the discretion has been exercised properly?
Yes,
You know,
yes, only that much. And Lordship, so far as what is the level of discretion? On the last occasion also I had.
And first we have to see that as per the governing law, NI check on. As per the governing law, we'll come to that. First,
Yes.
we should always read the facts.
Yes, yes.
That as per that law, what is that judgment? Okay, Deshwal, or there's a
Oh,
judgment
yes,
leading case.
SS Deswal, I think.
Deswal.
SS Deswal.
So yeah, first we have to determine that question that in terms of the statutory language, it appears to be mandatory. But what is the interpretation of the Honorable Supreme Court
Yes.
as to whether what is the current position?
Yes.
You know that
Yes.
whether it is mandatory.
Yes.
Right? Only if it is discretionary, then we can examine the next aspect.
Of course.
That whether the discretion has been exercised rightly. Okay. Let us be with the facts first. So, $15 lakhs. Check amount. Bill is admitted. You can work inside. Subject to the condition that will deposit 20% of the amount. Fine. I've gone through this.
Yes. So, Lordship, in this impugn order, no, first of all, should I submit on whether it is discretionary and whether discretion was?
Yeah, we can take up that issue.
Yes.
Because
So Lordship-
let us see the statutory
Yes.
provision first. Right, may. The word used is may.
Yeah. And some confusion initially was there because of the judgment in SS Deswal that it is that the court cannot come below 20%. And thereafter, after
No,
the
because
judgment,
statute says minimum 20%.
yes,
May or uses the word may, but if given,
so statute
minimum
says
20%.
it's either it's 0 or 20%.
Either it is 0 or 20%.
Or 20%.
Okay.
Now, Lordship, whether
20% or more, minimum.
minimum, yes,
Anyway.
yes.
Hmm.
So thereafter, Lordship, some change in interpretation in the law has occurred, because of which this case stands. Otherwise, in view of SS Deswal, this case would not have stood.
Fair.
That is also fair. So after this, a bench of similar strength in a judgment which I had provided on the last occasion, that is Jambu Bhandari's, I don't know whether it is kept in record or not.
I've
But
heard
I
about
have got another-
that. I heard about that judgment, Jambu Bhandar.
Yes. So this had brought in some change in interpretation. Sir,
You have a spare copy?
I can provide my.
Asi copy আছে copy আছে
You have a spare copy, otherwise we make a
extra
photostat.
copy আছে
Photostat provide in item. Because you'll need a copy. No? Read. Okay, this has come. Quorum is same, 2.
Quorum is same. But then later judgments had followed this interpretation. So later judgment also I have brought. And wherein it was also clarified. So now to some extent discretion is left, and guidance to that discretion is provided in a later judgment, Muskan Enterprise, which also I have brought. Earlier, no scope for discretion. This judgment brings in some discretion, and in what way that discretion is to be exercised.
That is in the
That is
third
in-
judgment.
That yes, a later judgment.
Costly.
From para 26 onwards, this matter was dealt into, because here in this case, the facts were such
Muskan.
that, yes, Muskan Enterprise. So here in this case was that under 482, such an order was challenged. At that time, SS Deswal was holding the field. That was rejected on the basis of SS Deswal. Second time again, when the law changed in view of Jambu Bhandari, there was a second 482 application that was rejected, and thereafter they went to Supreme Court, and the Supreme Court says that from para 26 onwards, this interpretation is given. And para 27 talks about in what, although the list is not exhaustive, but in what circumstances this discretion can be exercised.
Para 90.
Para from 26 onwards, para 26 onwards.
Muskan.
Muskan. Shiv, I have got a soft copy. I can read
Which one?
this judgment.
Okay.
So I'm reading from para 25.
Okay.
It is also a well accepted rule that interpretation must depend on the text and context. The text representing the texture and the context giving it color, and the interpretation would be best, which makes the textual interpretation match the contextual. While wearing the glasses of the statute maker, the enactment has to be looked at as a whole, and it needs to be discovered what each section, each clause, each phrase, and each word means, whether it is designed to fit into the scheme of the entire enactment, where no part of a statute and no word of a statute can be construed in isolation. Statutes have to be construed so that every word has a place and everything in its place. We draw inspiration for the above understanding of the manner of interpreting a statute from the decision of this court in Reserve Bank of India versus Peerless General Finance, etc. Now, para 26, wearing the glasses of the statute maker, we need to read the text as set in the context. What is most significant is that the legislature has used both the verbs may and shall in subsection 1 of section 148 NI Act, but in different contexts. As we read and understand the subsection, what we find is that the verb may implies discretion. And if intended to have its natural meaning, it would refer to the discretion discretion left to the, it would refer to the discretion left to the appellate court to determine as to whether such court should order any deposit to be made by the appellant or not, pending hearing of the appeal against the conviction and sentence recorded by the trial court. What Jambu Bhandari Supra lays down is that deposit may not be ordered if the appellate court finds a case to be exceptional, not calling for a deposit, and the reasons for not ordering a deposit are recorded in the order. On the contrary, the verb shall, used in the same sentence and distance from the verb may by 8 words, typically implies an obligation or duty that is referable to the quantum of deposit. That is, the deposit in any case must not be less than 20% of the fine or compensation awarded by the trial court. What follows is that once the appellate court is satisfied that the deposit is indeed called for in an appropriate case, such court's power is in no way fettered to call upon the appellant to deposit more than 20% of the awarded compensation. But in no case it can be less than 20%. Interestingly, while the proviso to subsection 1 and subsection 2 of section 148 use shall in the relevant context, subsection 3 again reverts to may and its proviso to shall. User of the verbs may and shall in different contexts in the same section is clearly suggestive of the legislative intent to mean what it said. We may take the discussion a little forward to emphasize our point of law. There could arise a case before the appellate court where such court is capable of forming an opinion, even in course of considering as to what would be the appropriate quantum of fine or compensation to be kept in deposit, and that the impugned conviction and the subsequent sentence recorded or imposed by the trial court is so wholly incorrect and erroneous that it is only a matter of time for the same to be set aside, and that ordering a deposit would be unnecessarily burdensome for the appellant. Such firm opinion could be formed on a plain reading of the order, such as the conviction. Some examples are given where this discretion can be. The conviction might have been recorded and sentence imposed without adherence to the mandatory procedural requirements of the NI Act. 2, prior to or at the time of lodging of the complaint. In our case also, there is an issue that we had not received the advocate notice. Requirements prior to, okay. Or the trial court might have rejected admissible evidence from being led or relied on inadmissible evidence which was permitted to be led. Or the trial court might have recorded an order of conviction which in its ipsi dixit, without any assessment or analysis of the evidence and or totally misappreciating the evidence on record. Or the trial court might have passed an order failing to disclose application of mind or sufficient reasons, thereby establishing a link between the appellant and the offense alleged and found to be proved, or that the compensation awarded is so excessive and outrageous that it fails to meet the proportionality test. All that which could evince an order to be in defiance of the applicable law and thus liable to be labeled as perverse. These instances, which are merely illustrative and not exhaustive, may not arise too frequently, but its possibility cannot be ruled out. So some list is given and then say that it is not exhaustive.
Yeah.
This kind of situation
Usually
may
these
arise.
things are non-exhaustive only.
Yes. So therefore, ultimately, what it is held that it is
So
discretionary.
This is the legal, no, not really. It's because the discretion of not giving can be exercised only in exceptional circumstances, some of which have been given.
Some of which has been
Have
given.
Not as a routine discretion, not a
Not
routine,
as a routine, yes.
not as a routine discretion. In
Yes.
discretion which will require some special circumstances.
Yes, yes.
Some of which have been enumerated.
Some of which
That
have been
means
done.
on the face of it, the conviction is erroneous.
Yes, yes.
Something similar to the principle of bail, which we
Yes, yes,
give,
yes,
you know.
yes.
Well,
Because Lordship
in
ultimate-
stiff sentence.
Yes, because ultimately it's an appellate court. In appellate court, the case that's what they are saying, that appellate court, the case won't go on for very long.
Hmm.
Because it's just 1 or 2 dates. It's just a hearing, no evidence or anything will be taken.
Hmm.
So ultimately you take a deposit and after 1 or 2 days, 2 months, 3 months, this again goes away. Again returning the deposit and everything, that's also a hassle.
Anyway, so this is the position.
Yes.
So now we have to see the reasons given by the court.
In
That
this,
makes
yes, in the
sense. Context
impugnation.
of these
Yes,
illustrations.
yes.
Reasons, and then why you think those reasons are wrong,
Yes.
according to you.
Now, first of all, one thing I would like to point out in page 74, that is the impugn order.
Para 11 to 26, para 11 to 22, I think, are the reasons. Yes, 2020. Para 11 to 20 are the reasons.
And it's the provincial election.
682.
680. So, Lordship, on the first page also, I would like to just show one thing for a moment. That is, first page means page 74. Para 4.
Mhm.
So here it is seen that the Honorable Session Judge sends this case to the Additional Session Judge Borpeta.
Mhm.
It has come up for the first time. Case record is received, and the Additional Session Judge is taking this for the first time. So what para 4? Para 4, it doesn't seem right. The Learned Counsel for Respondent, Srimati Krishna Bayon Das, is notified and he is present.
Yeah, entered appearance.
That now and entered it. Now present. Now this thing, whether because this lawyer is not a standing counsel. I may be in a writ petition. Suppose
That's
I
a different thing.
yes,
But
that is
he
what.
might have filed a wakalatama already.
Now
But anyway, we don't know.
that we don't know, and that is why perhaps on the first date the records were called for, which are not before this court. which
Records have not come.
That has not come.
Records won't be necessary.
Now,
But we can,
if this thing we have, because on the first day,
reasons we can see from here only, whatever he has annexed.
Record is not required, Lordship.
Not required according
Not
to.
at all, Lordship. Because
No,
they
no,
are limited
if-
challenge. Their challenge
No.
is a limited part, Lordship.
That's true. We can see the reasons from the reason, as I said, para 11 to 20 are he has discussed before ordering this deposit, right?
yes,
He has, the learned court has discussed. But in the context of these rules, sorry, this examples which have been given
Yeah.
in this decision, Muskan.
Muskan Enterprise.
That whether suppose we have to see that whether the impugned judgment of conviction is on the face of it wrong, then we have to see the records.
Judgment is there, Lordship.
We have to see the records.
Judgment is there, appeal memo is there, Lordship.
Anyway, let us try, because otherwise again I'll be handicapped.
Yes.
The judgment and records, everything has to be seen in the context of depositions.
Most probably,
everything has to be
Lordship.
seen.
In my humble record will not be required because it is a limited, they have come
Yeah.
up with a prayer with a limited part, Lordship. With that 20 award of 20% each, justified or not,
Yes.
that much only.
Okay. No, because as I said, I don't want to repeat it, but because these are the things, whether the examples which have been given,
Because-
rendering whether there was a suppose bar of, suppose it is 15 days was not complete, suppose 1 month is not
that is
complete.
one of the points. Yes.
Those are not challenged, Lordship. These are the impugned judgment is there, their appeal memo is there,
But
and the revision grounds of revision are there. Lordship.
this has to be seen, whether the court has relied on inadmissible evidence. This will require a record.
I am of the humble opinion, this court is
Okay.
not sitting as an appellate court here, Lordship. It is a power of
Inherent powers.
Revision,
inherent power
inherent
only.
powers.
to limited question only, Lordship.
No, this was this thing only.
This is only limited question,
No,
Lordship.
this Muskan Enterprises arose out of 482 only.
That is also 482.
Anyway, we'll cross the bridge when it comes. If you can manage with this, it's good for you, save you time. And if we feel handicapped, then we'll take a call on that. Anyway, proceed. We'll not backtrack. Proceed. You proceed.
Yes. So, Lordship, one thing I wanted to show is that without being a standing counsel, a counsel was notified and he accepts notice. So no notice was sent to the other side. No formal notice was sent. Number one. And secondly, para 7, para 10.
This aspect will also require the records. in a way.
That's the thing. Whether and this aspect, along with that lawyer has also filed petition for interim compensation. Paragraph 10.
Hmm.
Now, on the first day
Interim
appears
compensation can be given by appellate court also.
interim under 148. I mean, this thing only because the because the
I'm
honorable
not
judge,
sure, so I must.
because the honorable appellate judge has the power as per 148 to otherwise also give. But here they have allowed this petition. Now, what I am raising here is that a lawyer appears for the first time. He was notified and then he appeared. That means the lawyer doesn't know that today the case is there. for the first time appears and also files a petition, and that petition is allowed. Whether
That-
instruction was there from the client or not.
Kindly
on
read,
record.
kindly let us go through this. Kindly read.
All right.
Let us read from para 11.
Yes. Lordship has, of course, seen para 10.
Para 10 I've seen.
Yes.
Wait for interview.
Yes.
The appellant has submitted that.
Yes. Then para 11, the appellant has submitted that the demand notice in this case was issued to a wrong address, and the same was not received by the accused appellant. Hence, this is an exceptional circumstance in this case, and so the appellant may be exempted from paying 20%. So if this prayer is to be seen, this is again in Muskan Enterprise also, whether before filing a case, the prerequisites are satisfied or not, because notice is one of the prerequisite of filing an NI complaint. Then it is also para 12. It is also submitted that the accused appellant did not issue any check in favor of the complainant, but the checks were given to her husband for obtaining a loan. So, Lordship, this is a peculiar case where not a single penny has come to my account.
This is
Even if
true
I
that-
admitted position is that all the money went to my husband's account, and I am made the accused. And what our plea was that some blank thing, because we had a friendly relation with the complainant party also. That is also there. And these checks were taken from us. It was in our card. They often used to use our card. These checks were taken. These were actually given to my husband. These checks were handed over. These 2 checks were handed over to my husband for taking a loan. And we have also provided in our evidence that we have actually taken a loan, but extra checks were, blank checks were kept in the card. From the card it was. So that is one of the point. Then it is also submitted. 13. It is also submitted that there are several discrepancies in the evidence of the complainant. As such, the appellant may be exempted from payment of interim compensation. So this is again a general thing. Several discrepancies. I don't know what they have argued, but in order, discrepancies are not exactly highlighted. I have perused the record, para 14. I have perused the record, and it is seen from the impugned judgment that the learned trial court had observed that notice was deemed to be served and the same was issued by registered post to the correct address. So this was the finding, but evidence says that is there in the trial court judgment also, that the PIN code was wrong, which they have admitted. And that was a rented accommodation. We went to our own permanent accommodation at the time. That is our point. And so far as the wrong PIN code, that has come in their evidence also. It is also revealed from the evidence. Ultimately, it was deemed this service was also deemed to be taken. It is also revealed from the evidence of the accused appellant that she has admitted that at the relevant time, her official address and residential address were same, which is mentioned in the complaint petition. Now, this so far as wrong PIN code, this thing has not been reflected in the order. So this is again misappreciation of evidence on record. And moreover, the accused appellant could have paid the money. Now, this Lordship will see this reasoning. Moreover, what kind of reasoning is this? Moreover, accused appellant could have paid the money after receipt of summon of the case. My lord, when we are challenging, why we will, after receiving summon, we will pay the money? As if this is a mistake we have committed, that after receiving summon, we could have...
Evidence of accused appellant that she has admitted relevant time her office and residential address were the same, which is mentioned in the complaint petition. Anyway.
Yes.
So this again has to be cross-checked from record.
Yes.
Anyway.
And moreover, this reasoning, it can be seen, this reasoning, moreover, the accused could have paid the money after receipt of summon.
Okay.
Is it necessary to receive if I'm contesting the case?
Anyway, so
if she really did not receive demand notice, but she failed to do so during the trial, that means I should have paid during the trial.
Anyway, so
as such, it cannot be held that the above is an exceptional circumstance in favor of the accused appellant so as to exempt her from making payment of interim compensation. Then para 15, it is further seen that the accused appellant has admitted
the check belongs to her.
yes, check belongs to her, Hence, prima facie it is presumed.
Hmm.
A prima facie presumption is for
No,
the
this is a legal presumption.
there is legal presumption.
Under the
there is a
Act.
legal presumption, but a not irrebuttable presumption.
Yeah,
A rebuttable presumption.
You have to rebut.
Yeah, this presumption is to be taken by trial court.
It has to be rebutted.
Is to be rebutted, and
It can be rebutted.
we have given evidence that this was taken from us. He is not a holder in due course, because somebody has to be a holder in due course
Admitted
of
the
a
check
negotiable
belongs to her.
instrument.
Once the check is admitted, then it had this it shifts to the accused
Other side, yes.
to rebut the presumption.
Yes.
For further, the other contention.
Further, other contentions of the accused appellant to that effect that the check was stolen by the brother of the complainant, or there are certain discrepancies in the evidence of complainant, would be taken into consideration at the time of final hearing of the appeal. Now, this was dealt in this way.
The prima facie determination can be seen about the stealing of the checks, the stealing of the checks or whatever,
Yes.
In my
To that effect, no determination is made by this court. They say that
because
to that effect-
usually when a checkbook is stolen, it should be reported to police, something like that.
Yes.
In my considered opinion, the facts cannot be so.
Yes, 17. In my considered opinion, above facts cannot be an exceptional circumstance.
Whatever.
Yes.
Yeah,
These are the reasonings.
these are the reasons. Okay. Okay. These are the reasons. Should I move to the
Yes.
side? Yes. You make your summation, sir.
My-
Then we'll see whether we can do it without
My lord.
with these materials only.
So far the legal position is concerned, Lordship, there are 3 judgments. As to the SS Deswal, it is make mandatory, may should be read as sale. Then the Jambu Bhandari and the Muskan.
Mm.
Just for the purpose of reference, I am saying regarding the binding nature of the judgments of equal strength of benches. Lordship, in the Pranay Sethi, the constitutional based judgment, National Insurance versus Pranay Sethi, it has been held the earlier judgment should follow.
No, these two are not in conflict, in my humble opinion.
Lordship,
It has fine-tuned the law that
earlier it was
Deswal says that it is mandatory. The second judgment does not say this. Jambu Bhandari does not say it is not mandatory, but in
exceptional
exceptional
circumstances.
circumstances.
I am fully agreeing on.
Yes.
First time,
Just
just for the purpose of
tried to
referring to
harmonize.
the Sethi part, Lordship.
Yes.
Now coming on the merit, Lordship. Here it is a case, the Jambu Bhandari, Lordship, which I would like to read, Lordship. Just point out from para 6 onwards, Lordship. Most probably have the same citation, Lordship.
Yes.
Para 7, Lordship, sorry. Therefore, an appellate court considers, para 6 onward, whether what is held by the court is that purposive interpretation should be made to section 148 NI Act. Hence, normally appellate court will justified in imposing condition of the deposit as provided under 148. However, in a case where the appellate court is satisfied that conditions of deposit of 20% will be unjust, the words are unjust, or imposing such a condition will amount to deprivation of right of appeal to the appellant. Exception can be made for the reasons specifically recorded. Here, Honorable, the First Appellate Court, London First Appellate Court has mentioned the reasons. Now coming here, Lordship, appeal has been admitted, Lordship, here. In this case, the impugned order says appeal has already been admitted. The only 148, the amount has created a conditional stay or suspension of the sentence part,
Conditional
Lordship.
stay.
Not here this first regarding right of appeal will amount to deprivation of right of appeal. That is not there, Lordship. Appeal has already been admitted. It is pending.
When in a case where the appeal is at a condition of deposit. will
No,
amount to deprivation
stay
of right.
is suspension of sentence is condition. May I read the order, Lordship?
Suspension of sentence subject to that. Yes.
May I read the order again, Lordship?
That is true.
If permitted.
No, suppose he is imposed with such an amount that he is unable to pay, that will amount to depriving him, then the stay has to be vacated. If stay is vacated, the appeal
No,
will
that
be
has
infructuous.
Even Lordship non-deposit
In
today,
that sense it
as
is.
on today, they have not went to jail. We are not imposing that part also, Lordship. So here the appeal is admitted.
Right. Only
The
stay is subject to
148
that.
is conditional to
It is like that only.
only suspension
It
part.
is
Lordship.
it is given like that
So
only.
this part of Jambu Bhandari, Lordship, that they have not been deprived. Now it is burden on them to show whether there is any exceptional circumstances, Lordship. The first ground my brother has referred here regarding service of notice part, Lordship. After the judgment of C.C. Alvia Haji, Lordship, Honorable Supreme Court 3-judge bench judgment, Lordship, if anybody takes the plea that I have not received the notice, that's why I could not make the payment, he can make the payment within 15 days of receipt of summons. That was the 3-judge bench findings. Lordship, as you are aware of that part.
What is the name of the
C.C. Alvia Haji, Lordship.
Alvia.
So
Yeah,
they can make a prayer before the court. Okay, we have not received the notice, but we have received the summons. This is our due. We are paying. Please exempt us from
For
trial.
encouraging settlement.
Not settlement, Lordship. Proceeding has to be quashed in C.C. Alvia Haji part.
Yes.
Only on the ground of non-receipt of notice. Here in the trial court, Lordship, if I refer to para 47, Lordship, page 47 of their first appeal memo, Lordship,
There are 47.
page 47, Lordship, para 61 onwards, page 47, 48, Lordship, in the trial court judgment.
Okay.
They have given, Honorable trial court has given the address, both the parts, the notice sent, and given findings that it has been properly served, deemed to have been properly served. A long reported judgments are there, case Sankaran, that a propolis may avoid notice on this or that grounds. And to overcome that also, the C.C. Alvia Haji judgment was there also, that even after notice cannot be a ground now, after the C.C. Alvia Haji. The next part is, Lordship, their ground is stolen of a check. In these two cases, Lordship, just I beg to point out, Lordship, in two cases, in one case, the appellant has taken the money on her own, rupees 10 lakhs, and the other case, at her direction, money was transferred to the bank account of her husband. At her direction, and she has issued the check. Here the liability comes on issuance of check. That part has been admitted, Lordship, that yes, these are my signatures. I have issued the checks, though they have taken the plea of stolen, that checks were stolen or missed from their car. All these facts have to be go to the trial, Lordship. Once trial court has convicted, now they cannot take the plea of innocence. A judgment is against them. It is the appellate court to go on merit of the case, Lordship. For the limited purpose of a 148 order, they have to make out an exceptional case, Lordship. Like in 143, trial court's power to order during trial. But in 148, because a convicted person here, one court has given his findings.
Yes. That's true.
So footings becomes different, Lordship. Here.
Yes, that's all.
Trial court's footing and the appellate court's footing.
Right.
Recently, Lordship, Honorable Supreme Court, this though it is in respect of speedy disposal of NIACT cases, this Sanjeev Stari, the earlier Damodar as Prabhu, this compensation part was been reduced part. Some observations has been made here also regarding 143 even, Lordship. Some directions have been given at para 20. Just I am giving only for reference part, Lordship, here. This 2 lakhs part, cash deposit parts, all has been.
Yes.
Sanjeev Tari,
Recent.
Sanjeev Tari. This is for speedy disposal. Some new guidelines have been given.
Yes.
that during pendency, if I pay
Mhm,
the amount,
mhm.
then also court
Yes, yes.
can
Yes, yes.
compound the offense or even convict the accused, go on for probation,
Mhm.
release him on probation.
Right, right.
Here also in 143 part also, Lordship. So for cash deposits are concerned, para 20 is there, Lordship,
Mhm.
that cash deposits may be a violation in Income Tax Act,
Mhm.
but those do not make a check, non-enforceable liability.
Mhm.
In 143 part also some observations have been made. It should be given. It should be given because the object of 143 bringing 143 and 148, Lordship,
Yes.
is very much clear. Because in our case, Lordship, the trial begin in the year 2018, Lordship, 8 years past.
Yes, yes. That is the backdrop in which, the person who, in a case which is proved,
Lordship.
not with regard to this
Because
case.
here in the
This
appellate,
case, it's open. But thing is that those things have been passed, made, these laws have been made in the context that a person who has genuinely lent money, he
Yes,
has to
Lordship.
go around running.
we are in the same position here,
I don't
Lordship,
know, this I will not say anything
because we have
it
transferred
might
the amount
prejudice them.
to his husband's account, to our my wife's bank account here.
But in that backdrop, in the view of some such experiences or many
This
such
case is of
experiences
2018, Lordship.
of some of people, these changes have been somewhat stringent provision has been made, right? But however,
We have
interim compensation by a trial court stands on, in my opinion, stands on a different footing than this. Because
Appellate court,
at that
Lordship.
time, it is still guilt is still to
Yes,
be determined. But here, the one court has determined
already
me
determined
to be guilty.
Yes, Lordship.
Now I have to convince the appellate court that
Lordship.
it's wrong.
Absolutely, Lordship. Here I have money was advanced on 2017,
This is
Lordship.
a very fair
And I'm
judgment.
running
I
through
think these three are very harmonious judgments.
Lordship.
You
All
pointed-
I agree,
Thank you.
Lordship.
These are very harmonious judgments, that good you placed it like that. Thank you.
Exceptional
That,
circumstances, they have to
this law statute, then the law comes, then the law is, the window is open, and the contents of that window are fine tuned again.
So for the exceptional
It's a
circumstances,
very harmonious set of three judgments. This is a law.
just I would like to refer to your judgment of your Lordship in respect to 143A. What can be the exceptional circumstances, Lordship?
The 143 is interim compensation.
Interim
But here we are
compensation.
not on it. It's a deposit actually. Deposit.
No, just I'm referring the only for the exceptional circumstances, Lordship. That yes, stolen away, no FIR in this case, our case also no FIR, Lordship. Simply they are saying that my checks have been stolen away. She is a medical officer, Lordship. In a government service, she is now working in a medical officer as a medical officer under the government of Assam. She is not a
But here, as far as on the question of FIR, the checks, they are supposed to have been stolen by the complainant's brother. That
Complainant's
means
brother, not the complainant.
if he was aware, then he should have filed a
yes
FIR.
FIR.
But was he aware that it was
Definitely, they are taking the plea. Plea has been taken by them, Lordship.
anyway? No FIR. Anyway, next submission.
So my humble submission, Lordship, they have failed to make out any exceptional case, Lordship, here. Passing of this order
And therefore
did not create any hinder in the admission of the appeal here, Lordship.
So therefore, the deposit is justified according to you.
And amount is only 6 lakhs, Lordship, out of 30 lakhs award.
30 lakhs.
They have to deposit only 6 lakhs. With this, my humble opinion, Lordship, my humble request, Lordship, matter may be disposed of, Lordship, with the available records.
You reply. Will I be able to dispose with the?
Yes, Lordship, yes, Lordship.
Otherwise, I'll reserve it. Otherwise, I'll have to again fix it for to be spoken to. And then
Lordship,
again.
I leave to your Lordship. Actually, the thing is, I am a government doctor. I am not running away anywhere. And the thing is, only it is so far as because it's an appellate court. It's not that a trial court. Trial will continue for another 10 years. Appellate court at the most what? From this room to another room.
If
the
my
record
brother is
will
saying that, Lordship, that court is lying vacant, Lordship, for last 3 years, Lordship.
Which court?
This additional session judge court, Lordship.
Okay, that I am not aware.
That after transfer of the officer passing the award,
No, these
court is lying vacant,
filled
Lordship.
up.
There is a
I'm sure now it will be
difficulty.
filled up. It will be filled up soon.
That court is lying vacant, Lordship. Our case is also I have taken up a date, Lordship, this NO is going on
We
there.
cannot afford to, we'll fill, it will be filled up. That part will
Because
be
there is
done.
an administrative part. There is
No, I am saying that, Lordship, just,
Yes.
my brother is saying that it will
Administrative
be
part is
1 day
also-
matter, may not be a 1 day matter.
But
Lordship.
administrative part is
Unless
also
filled up-
related to judicial part.
Unless filled up, then
It is-
again my matter will remain
No,
there.
no, administrative part is also related to judicial part. It is, because the case get hold up like this.
Just I have given that date,
No,
Lordship,
I understand.
NO, because
Hopefully it will
court
be
is vacant.
filled up soon. It's fine. Nice submissions on both sides, but on my only concern is that because I don't have the record, I have the judgment, because I cannot judgment whether this finding of judgment is correct prima facie.
Yes.
I will have to cross check. I don't have the
Because
depositions.
my
I don't
again-
have the
Actually,
depositions
now-
with me.
now, Lord, the thing is that on the first day records were called for, but I did not start with that submission today because I also on my part, the other side should not think that on that pretext I'm trying to delay
No,
something.
I don't.
That is why I
But
made
yes,
at last
report-
time.
Because it is a district court, Lordship, as aware.
The case record was called for, but
Yes, 8 months back. 8 months back, they should have
record
planned.
was-
I mean, this also is.
case record, call for the case records of the trial court as well as appellate.
Thereafter, Lordship, another order is there, Lordship. Next order is there, Lordship. Court has given them a chance. They have agreed to pay something, but
Now,
due to
Lordship,
this,
how-
due to the difficulties of minimum 20%,
Yes.
Lordship. That is the, this
Yes.
is the difficulty of minimum 20%, Lordship.
Now, how things have went after that? After that date, it had come before another bench. Another bench wanted to, solve the issue, Lordship, and send it back by giving some amount. But
See,
then,
the thing is that one of the trustees, it has been mentioned in judgments also, though it is criminal law, but thing is that the main trust of this not to punish the person actually.
yes,
These are,
if I go
these
to
are,
jail,
the whole objective of this law is to ensure that, the system of check transactions remains smooth.
yes,
Because
yes,
if people start issuing
yes,
checks,
so, yes, yes.
I'm really surprised that so many check bouncing cases happen in our country. Does it happen in other countries also? I want
Now,
to know.
folks are going
You
out of
and me
fashion
will
also.
not issue checks if we don't have the money. We'll check. No? It will be embarrassing for us.
Yes, yes,
We will check,
That's
or we'll
true.
tell ki I have given you, but don't deposit. I'll inform you.
Yes.
Something like that,
But
right?
Lordship, in our
So
country,
many checks.
in
check
our
bouncing
country,
cases.
banks are taking, the State Bank of India is also taking blank checks as security. These kind of things are happening. It is officially, unofficially, I don't know, but they take around 5 to 10. If we have any experience of loan, we know that.
Yes. Things that true. That is true. But case record, the very recent office note also says 1/4/2026 that case record is not yet received.
Now, because on the next, after first, the day of money, Lordship, we have both agreed that yes, matter can be heard without the record, Lordship. Accordingly, that's why case was fixed for, Lordship.
So I will reserve it. In
Lordship.
case I face handicap,
Yes.
then I'll have to.
So Lordship will
Go back.
reserve it, and Lordship, one thing which I pointed out.
Or there are two options, sir.
Yes.
One is to I reserve it, and if I can negotiate, fine, well and good. Suppose I run into difficulties, and that it's a question of justice,
Yes.
that I feel handicapped without seeing the records, then I'll have to make it, fix it for to be spoken to and call the record. That's
Yes.
one option.
Yes.
Other option is to keep it part heard and call for the case record.
I
That-
totally leave to your Lordship. I will
That
not
is it,
say.
Lordship.
What would be best?
discretion. We leave it to Lordship.
No, you must guide me.
No, we leave it to Lordship.
Lordship has heard for this long. If Lordship wants, can keep it part heard. I'm not against anything. I'm not saying cannot preserve, I'm not against anything.
As your Lordship deems fit, Lordship,
Yes.
Okay, let me
pass
try.
appropriate illustrate.
Let me try. If I get stuck, then I will call for the record.
Okay.
I'll do it fast because
And Lordship will.
otherwise it will waste time for you.
And one point, Lordship, which I have maybe that much, because whether the judgment, this appellate court order, the impugn order, on the face of it, whether it is passed properly or not, that one point which I had, that advocate was notified. He came on the first day, filed a petition.
That was the district court practice, Lordship.
How much that is proper?
Because once CIS comes there, case filed, then it comes after transfer of 2 days or 3 days. Normally, same lawyers are there.
No, that is normally, but
Limited
we
lawyer.
cannot know. The other party may engage other lawyer also. Here also in writ appeal, if we go, we don't accept notice on behalf, unless we are standing counsel for a department. They can, they are the
No, you
standing
have to,
counsel.
no. That privately you have to be given the power.
For each and every case, appeal is different.
Anyway, so okay, I will pass the order later. So I'm
Lo-
reserving it.
Lordship.
I'll try it.
Yes.
If I get stuck, then I'll come back to you.
Lordship.
To be spoken to, it will be fixed.
কোনটো 6 7
দুটো একেলগে
দুইটা
একেলগে এটা এই লিখকচোন কষ্ট heard you're Mr.
MK Chaudhary
MK Chaudhary, Learned Counsel, MJ Chaudhary, Learned Counsel for the petitioner, and SK Podda, Learned Counsel for the respondent complainant. Though the scanned TCR has not yet been received as per office note dated 1/4/2026, both the Learned Counsels expressed their desire to conduct a hearing and submit that perhaps it may be possible to dispose of the matter with the existing materials. Accordingly, this court proceeds to hear the matter. Arguments are addressed by the respective learned counsels. Judgment is reserved.
Obliged.
Right one. Let us finish this.
Maybe listen.
My lord, just one thing, my lord, I'm just seeking your lordship's indulgence. I'm not seeking an adjournment. my lord.
Not so.
Only thing is, my lord, in 412, my lord, there's an item 22, not now, my lord, 14 is going on, my lord.
Okay.
Just a contempt matter. If
Okay.
my lord permits
You're
me,
clear,
I'll
clear.
just, my lord, go in
Yeah.
between and I'll.
That's no tension, this court.
Lordship,
You should enjoy your this submissions. Anyway, but I think that day he had made a submission. You had made a submission.
Yes,
I studied a bit. There is a judgment of our court also. Kulita. You may have that has discussed the aspect of this confiscation criminal side. But I also read that the after amendment of subclause 4, there is also a process of administrative confiscation as you had
Yes,
submitted parallel, and which ends with appeal to the district judge.
Appeal to the,
Thus,
exactly.
It ends
Exactly, my lord.
formally, that's the last
Yes,
time.
ma'am.
Of course, constitutional provisions are always there. That is there. So, this much only I have studied. Beyond that, I have not. I have to go deeper. I have to see that judgment and see the other aspects also. So, but you complete your thing.
Yes, ma'am.
I have some time. I'll complete it.
Yes.
I'll start writing.
Lordship, before starting my learned friend, Lordship, just I would like to mention one thing, Lordship. In my affidavit, Lordship,
No,
one at a what?
No.
Times.
no. So, no, so after some time.
It's just one
Yes.
one word, Lordship. I have actually a mistake, Lordship, in my additional affidavit. Lordship, there is case 44. Paragraph number 11. And fourth line, Lordship, which is not discarded by the Honorable Court, this court as well as the apex court. Lordship, this is not discarded, it is raised or discussed over.
It's hardly matters. I understand.
Lordship, in this case, Lordship, I have annexed, Lordship, the trial court judgment, Lordship, appellate court judgment, Lordship. In this,
It's okay. It's okay. Yeah, this was necessary. So we now it is complete. Huh?
Lordship, now,
The
Lordship, there
materials
are
are complete.
Lordship, Lordship is very much already last occasion has gone through, Lordship, and page 52. Lordship, this is the here it is also mentions, Lordship, that confiscating proceeding is apparently is of a temporary nature. So, Lordship, it's mentions, Lordship, page 52, paragraph number 18, and in paragraph number 18, Lordship, after 6th line, which apparently is a temporary nature. And Lordship, here in Lordship, paragraph number 21, there is a direction was there, Lordship. That directions, Lordship, is still not earlier occasions not raised by before this honorable court as well as the apex court, Lordship. That point is still there, Lordship. Lordship, this direction has been given, Lordship, to the forest authority. Initial direction has been given, Lordship. The liberty has been given to the petitioner to submit the grievance before the concerned forest authority, and such authority is also directed to consider such player to release the the seized vehicle in accordance with the law, Lordship. That part, Lordship, neither earlier occasions before this court as well as apex court has been raised or discussed, Lordship. But then now, Lordship, second page 54, this is the High Court order, revision order, Lordship, earlier against this appeal, Lordship. But in this case, Lordship, his appeal has been, revision has been dismissed on the ground that, Lordship, so there are no mistake or apparent wrong is found, Lordship. But that what is the directions, Lordship? It is the paragraph 21. It's not raised or did not discuss anything, Lordship. Now, Lordship, kindly come into page 66. This is the apex court's judgment, Lordship.
There's two lines.
Two lines, just.
There are many SLPs are discussed at the outset.
Lordship. So, Lordship, my submission is that, Lordship, whatever direction has been given in paragraph number
The reasons are there. They've
Yes.
studied the file,
Yes,
but it's not written in law.
yes, Lordship.
This is
So,
the
Lordship,
system.
So, Lordship, in case number 67, that is the letter, Lordship. That this letter was issued, Lordship, pursuant to their directions, Lordship. That is the appellate court's direction was that paragraph number 21. That this letter has been issued. That means in this letter, Lordship, this reveals that you can take your vehicles. So, Lordship, apparently, Lordship, thereafter, Lordship, petitioner was appeared. And but that time, Lordship, the forest DFO has informed that as already case is pending before this honorable court, we are not going to any object against this release. So you can suggested, at a suggestion has been given, then you can obtain an order from the court, High Court, Lordship. So this is the order, Lordship. And Lordship, in the case 70, Lordship, this is, Lordship, another judgment. This is it, at the time, Lordship, at the same time, Lordship, 4 vehicles has been seized. That is the one vehicle, Lordship. He also approached before this apex court, Lordship. In this case, Lordship, one observation has been given. Just I would like to, though it is dismissed, but observation has been given, Lordship, that case 71, second paragraph, Lordship, after 8 line, it's saying, Lordship, after culmination of all proceeding of offense, then vehicle should be released, Lordship. So it's Lordship code is very much our sections 52 of CRPC, now Lordship BNS 498. It's after conclusions of trial, if the accused is not convicted, then property shall be released, Lordship. So this part also mentions, Lordship, in this case, Lordship. And pursuant to this judgment, Lordship, that petitioner also got his vehicles by this honorable court, Lordship. So here my case, Lordship. But here my case is first, Lordship, that 8 years has gone. There is a notifications. Till date, they has not withdrawn. Lordship, in the last occasions, court has made a query, Lordship, whether court can make a direction to withdraw this case, or it is not correct. So in this regard, Lordship, my submission is that I have submitted a representation that is annexed with my criminal petitions, Lordship. That is the last page, Lordship.
Cases, just a question this has come to my mind. Those categories which have been mentioned in the government notification for withdrawal, all the cases which are falling in the categories, all have been withdrawn.
Yes, or similar case, Lordship, I have already annexed.
Or there is a discretion.
My lord, it was not a blanket withdrawal. My lord will see it was a guiding principle. That first judicial department's view, concurrence must be taken, and case to case basis, my lord, it was withdrawn.
Not blanket.
No, not blanket.
Lordship, my submission.
But the criteria is that.
Yes.
Only those cases.
Lordship.
Yes.
Lordship, kindly see case number 31. Similar
That
case.
only.
Similar case.
Yes, you have shown me.
Already withdrawn, Lordship.
Oh, you've shown me. Naturally, you will think like that.
Yes,
Similar
yes.
case has been withdrawn. Why not yours?
Yes. So that's why, Lordship, I am, Lordship, that's why.
Naturally, you'll think, anybody will think like that.
Lordship, that's why, Lordship, I'm praying for quashing. Yes, because this judgment is completely covered, and pursuant to this judgment notifications, Lordship, I have submitted and representations. Lordship, kindly see the last page, Lordship, 40. Page number 40. This is the note. I have categorically mentioned, Lordship, that there is a notification to withdraw the case, and several a similar situated case has been withdrawn. So my case may be withdrawn, and vehicle may be released, Lordship. When a case will be withdrawn or quashed, then there will there will no question, Lordship, to seize, retain my vehicle, Lordship. That is page 40, Lordship.
I've seen this.
Lordship.
You have shown.
Lordship. So, and so, Lordship, my first.
Let me tag it, not tagged. So I've understood
Lordship.
this case basically.
Lordship, my limited prayer, Lordship, 8 years gone, similar situated case has been withdrawn, and my Lordship, this case may be quashed as because Lordship, this notification is covered. They did not withdraw my case. Similar situated case had been withdrawn. And Lordship, one Lordship judgment I have submitted, Lordship, in the apex court judgment, Lordship, recent judgment, long pending.
Okay.
So that is a long pending is also a one ground. So here in my case, it is a petty offense, 8 years gone. So this on that grounds, my case may be quashed, Lordship. And now, Lordship, when my case has been quashed, everything has been gone. So my vehicle should be released. And in this regard, Lordship, I have already submitted our High Court judgment, Justice judgment, Lordship. Similar situated, Lordship, my that is my limited submissions, Lord.
Okay. Fair. Today is third.
Fourth, Lordship. Today is fourth.
Fourth. Oh. Yes. You can complete
Now, my lord, my first response is that, my lord, from time to time, my lord, my learned counsel is using the word pending, delay. My lord, I am, my lord, hitting the very core of this argument, my lord. There is no proceeding, my lord, pending. Because a complete, my lord, confiscation proceeding was initiated and it has finished, my lord. Petitioner has appealed. That was also dismissed, my lord.
According to you, this is this administrative confiscation.
Yes, my lord.
Not the criminal court
Not
confiscation.
the criminal. And
so it seems to me that, as you said, that day I could not appreciate so much your submission, but fully. But I think I again have to cross-check that it seems you are trying to say that there are two kinds now. One is the criminal court upon conviction.
Yes.
One is the administrative conviction.
Yes,
Of course,
yes.
whether property can be confiscated while proceeding is still on. In other words, whether such a provision is
Yes.
valid is another matter. Whether it violates Article 14, that will be a
That will be
that if the provision is challenged, then question
that
can
will
be
be
gone into.
exactly.
But as long as that provision is there, you have to only see whether the procedure has been followed.
Lordship.
Now, first, my lord, I'm
According to you, it is a
Yes.
confiscation proceeding on the administrative track, and it is attained finally.
exactly.
Right?
On the these are, my lord, the offense reports DH5 and DH6, my lord. For perusal, my lord may see for both the cases, my lord will see identical contents. So, my lord will see that the details of the owner and everything was included. Then, my lord will see history of the case has also been given, my lord, in the next page.
Which one? Same, no?
Same contents, my lord. May peruse any of the one, my lord. It will be same.
Brief history of the case.
Yes. Brief history, my lord.
This is which order?
This is the case record, my lord, by
Yes.
the divisional forest officer, leading to the confiscation, my lord. The offense report.
Offense report.
Yes. So, my lord will see then history.
I can keep it.
Yes, my lord. This is for your lordship's records. The history of the case has been, my lord, given.
Okay.
I would not trouble your lordship with the complete content, but basically some offense regarding carrying of logs, my lord.
Right.
And there are guidelines by Honorable Apex Court T.N. Godavarman that timber cannot be transported out of Northeast through trucks, my lord. So there is a, my lord, blanket law. And he was, my lord, claiming to transport these from Mizoram to somewhere, my lord. That also he could not substantiate, my, that he was not transporting it out of Northeast. And then there was discrepancies in his, my lord, details of the timber. Timbers were not marked also. So as per the provision, my lord, this a forest offense was detected. So my lord will see in the offense report, there is a clear finding that an offense has been detected. Now the next question is, my lord, what did the authority do, my lord? What step did the authority do? For that, I would like to take your lordship to the forest regulation, my lord. That is in the book of forest manual.
Alright, I don't do.
Provision 49. We had, my lord, dwelt on this, my lord, whether it is a seizure or confiscation, my lord. It starts from seizure, definitely, my lord, but it will end up in confiscation, my lord, when all the remedies, the subsequent remedies are exhausted, my lord. That's when it becomes permanent. Now the question is, but petitioner is, my lord, contending that there is no trial, there is no conviction. He is, my lord, his prayers are two. One, that as per this notification, his case should be considered. But that notification, my lord, will not apply to him because it is not a pending criminal case, my lord. Confiscation has started, finished, he has exhausted all remedies, and this notification was talking about criminal cases, my lord, not these proceedings under forest manual, which could be done by authorized forest officer, that is DFO. So definitely not applicable. It is not pending, or neither it is criminal nor it is pending, because it is the notification, my lord, is only talking about pending criminal cases. Second part of his prayer is that if any trial is going on, first he's saying no trial, then he's saying that long trial, that needs to be quashed, my lord. That will also be inapplicable. Why? Because I had already said, my lord, that a confiscation has happened, then confirmed by the district judge, my lord. High Court has also rejected his prayer, and Supreme Court also rejected his prayer. So it has attained finality. Now this this petition on the ground of long pendency is without any basis, my lord. Now coming back to, my lord, section 49. Section 49(2), my lord is already, my lord, now has seen what 49(1) contains. 49(2) has a very interesting phrase, my lord will see. If your lordship is at 49(2).
Yes, I am on
Yes.
49.
Every officer seizing any property under subsection 1 shall place on such property or the receptacle, if any, in which it is contained, a mark indicating that the same has been so seized, and shall, as soon as may be, either produce the property seized before an officer not below the rank of assistant conservator of forest authorized by the state government in this behalf by notification in the official gazette, or where it is having regard to the quantity or bulk or any other genuine difficulty not practicable to produce the property seized before the authorized officer, or where it is intended to launch prosecution against the officer. This is important, man. Where it is intended to launch prosecution against the officer. It means, my lord, the authorized officer has an option. He can just go for a simple confiscation without any prosecution, or he can go for a prosecution as well as confiscation, or my lord can also see that he can just go for prosecution, and finally the court convicting the person will decide whether the property needs to be confiscated or not. But as soon as, my lord, we know
No, in that case, suppose the property has been already confiscated by the administrative side,
yes,
then the confiscation pursuant to conviction will not apply.
exactly, my lord.
Is it correct? Or am I
That
saying
is
something absurd?
what it is, because the other provision,
It's
my
not
lord,
already confiscated. It will be
exactly,
like
my
that.
lord.
I'll read it, all study and analyze.
So this phrase, my lord, where it is intended to launch prosecution, means that we have the option either to launch a prosecution or to do this independently. Then, my lord, will see 49A power to release it subject to a bond. But again, this is a discretion, my lord. Discretion by the authorized officer. Then, my lord, will see review. So when that as release has not been exercised, then the petitioner had the option of review, which was exercised, my lord, in this case, and that was rejected. Then, my lord, we'll see 49C appeal. Appeal was also exercised by him, also rejected, my lord. So this is where the proceeding ends, my lord. As far as this proceedings is concerned, what my learned colleague has relied, and Honorable Justice Ujjal Bhuiya's judgment had also taken into account, was Section 51. But my lord, Section 51, if my lord is in Section 51, my lord will see, when any person is convicted of a forest offence, all forest produce which is not the property of the government and in respect of which such offence has been committed, and all tools, boats, carts, and cattle used in commission of such offence shall be liable by order of the convicting court to confiscation. So, my lord, this is a confiscation by the convicting court. Basically, my lord, the district judge's court will order this confiscation under 51.
Session judge. Session judge.
Session judge, my lord. Session judge.
No, Lordship, this is not session judge. It
No,
is-
no, no. Criminal
Convict-
case will be session judge.
No,
Criminal
Lordship,
case will be session.
Criminal case.
Appeal may be district judge.
no, Lordship, here is a 3 years punishment. It is magistrate, Lordship.
No, magistrate.
Magistrate, yes. As per
Magistrate.
punishment.
Magistrate,
Right.
right.
Then I would like to take your lordships to the affidavit filed by the petitioner, my lord. First, my lord, if we go
Additional affidavit.
additional affidavit, my lord may take up 1031, my lord. The criminal petition 1031, the additional affidavit. I would like to take your lordship to page 48 of that affidavit, my lord. This is the appeal order, my lord, under 49C, which was rejected.
Okay.
My lord may come to point 9, my lord, which is a part of discussions, decisions, and reasons thereof. Point 9, my lord. Section 49 of the regulation provides for seizure of property liable to confiscation. The procedure to be followed for seizure of property is laid down in the regulation itself. A bare perusal of the section 49 of the regulation would reveal that it provides for a stage prior to confiscation. In other words, it provides for seizure of property liable to confiscation. It is an admitted position that the seized timber has been ordered to be confiscated to the state of Assam by the impugned order. To a pointed question raised by this court, learned government pleader is unable to apprise this court as to whether or not there is any order of conviction and of confiscation under section 41 by any court. Apparently, no order of confiscation under 51 has been shown to be passed against the appellant as on date. So, my lord, section 51 is that provision, my lord, which we had just seen, that is regarding of confiscation by the convicting court. So, the court had taken into account this aspect. In a case where the authorized officer is empowered to confiscate the seized forest produce on being satisfied that an offence under the regulation has been committed, the power vests upon such officer for dealing with interim custody / release of the seized articles. And the officer concerned while dealing with a case of seizure of forest produce under the regulation should first examine as to whether the power to confiscate the seized forest produce is vested upon the authorized officer. And if he finds so, then he has no power to pass any order dealing with release of the seized vehicle. Point 12, the power of the criminal court regarding disposal of the property is made subject to the jurisdiction of the authorized officer, and the jurisdiction of the criminal court with regard to the main trial remains unaffected. The power of confiscation is independent of any proceeding of prosecution for the forest offence committed. So this is an important point, my lord. The learned trial court had already considered this aspect, that it was an independent, my lord, administrative confiscation proceeding, not dependent on a criminal trial. Man. Now, I would like to take your lordship to this honorable court's order, where again the prayer of the petitioner was rejected.
Order.
I would like to take your lordship to 58 of the same affidavit, my lord. This is the High Court's order.
58.
Page 58, my lord. Order starts at 53. 53 is the beginning of the order, my lord.
Mhm.
But I would like to take your lordship to 58. Start from 58, man.
Just a minute.
If I may read, my lord. Being highly aggrieved, the petitioner approached this court by filing the present petition on the following major grounds, amongst others. These are, my lord, the grounds raised before this honorable court. That the ground of detaining the truck and seizure of the timbers and the vehicles by finding that 132 number of teak logs were loaded, but as per transit permit, it was 129 numbers is false and fabricated. Point 2, my lord. This is important. That no forest offense is committed by the vehicle number as the teal logs were carried under valid transit pass, and that for convenience of transportation, 3 logs were cut into pieces, and as such, the number increases from 129 to 132, and the respondent number 2, without considering that aspect of the matter, arrived at a perverse finding. Then point 3, that the petitioner neither received any notice in form so and so, nor got an opportunity to adduce evidence for this defense, and without the notices in form so and so being served upon him, illegally confiscated the vehicle, which is against section so and so of the Assam Forest Regulation. That the respondent number 2 had confiscated the vehicle without giving any opportunity, and that the petitioner had sent his vehicle by loading potatoes from Coach Bihar, and while returning, the driver of the vehicle loaded the teak logs without informing him, and as such, he is totally unaware of the incident. 5. That the respondent number 2 has filed a complaint case before learned Chief Judicial Magistrate Kachar, against which the alleged allegation of commission of forest offense and trial is yet to commence, and the learned additional sessions illegally dismissed the misappeal, and that he purchased the vehicle on hire purchase and has to make payment of monthly installment, and that respondent has failed to appreciate the fact that the vehicle is exposed to sun and rain since the date of its seizure, and therefore it is contended to allow the petition. So, my lord, will see all these elaborate grounds were raised last time, including a ground that a trial is yet to commence. This ground was already, my lord, raised. Now, what is this honorable court's finding? That your lordship will see again in the next page, 60, my lord. 60 on top. My learned friend was in that proceeding, my lord. He had relied on these judgments, my lord. Second line will lordship will see Mr. Hug also referred the following case laws. So and so reported in 1991 GLD, and another one, my lord, reported in 2006 3 GLD. Then my lord may go to page 63, my lord. Point 14. Also, having carefully gone through the impugn order passed by the authorized officer, come divisional forest officer Kachar Silchar, I find that the provision of subsection 5 to 49 of the Assam Forest Regulation is duly followed here. In this case, in subsection 5 to section 49 of the Assam Forest Regulation, it is provided as under. Then, my lord, will see this is a content of 49.5, my lord. What the process of confiscation needs to be done. So, this entire process, my lord, it was given in this judgment. Then, my lord, paragraph 15. Thus, having examined the impugned orders in the light of facts and circumstances on the record, and also in light of relevant provisions of law, this court finds that the same suffers from no illegality or infirmity, requiring any interference of this court by exercising its revisional jurisdiction. Also, I have gone through the case laws referred by the learned counsel for the petitioner. I find that the above mentioned ratio are laid down by a coordinate bench of this court while exercising writ jurisdiction under Article 226 of the Constitution of India. And in the instant case, the jurisdiction exercised by this court is the revisional jurisdiction under sections 401 so and so of CRPC, which is only limited to examination of the legality, propriety, and correctness of the impugned order. And as such, I am afraid the risk laid down in the aforesaid cases would not come into aid of the petitioner. In view of the above, I find that the submission so advanced by Mr. Ihab, Learned Counsel for the petitioner, is devoid of any substance. As the vehicle has already been confiscated, the question of releasing the same in interim custody does not arise at this stage. Then, my lord will see page 65, para 18 of the judgment. In this judgment, this case of apex court has been cited.
Kallo.
Yes, my lord. Here, my lord will see the content. In so and so
In the
case,
context of Madhya Pradesh Forest Sector.
Yes,
Madhya
yes.
Pradesh Forest Sector. Okay.
but found relevance in this case also, where my lord Honorable Supreme Court has held that Section 15 gives independent power to the authority concerned, but the confiscation of the article as mentioned thereunder even before the guilt is completely established. This power can be exercised by the concerned officer if he is satisfied that the said object was utilized during commission of a forest offense and the protection is provided for the owners of the vehicles / articles if they are able to prove that they took reasonable care and precaution as envisaged under section 5 of section 15 of the Adhinian, basically the Forest Act, and said offense was committed without their knowledge and connivance. My lord will see this same standard also finds in the Assam Forest Regulation, where he has to establish, the owner of a vehicle has to establish that it was used without their knowledge. Second paragraph is also important, my lord. It is also held that criminal prosecution is distinct from confiscation proceeding. The two proceedings are different and parallel, each having a distinct purpose. The object of confiscation proceeding is to enable speedy and effective adjudication with regard to confiscation of the produce and means used for committing the offense, while the object of the prosecution is to punish the offender. The scheme of Adhinian prescribe an independent procedure for confiscation. The intention of separate proceeding is to provide a deterrent mechanism and to stop further misuse of the vehicle. So my lord will see two intent. Confiscation proceedings intent is that vehicles should not be repeatedly used for committing forest offenses. But for criminal proceedings, it is to prosecute the offender. So distinct proceedings. And my lord had seen that section 49 of our regulation also has given this option where if the authorized official intends to launch a prosecution, he may do so. But even without that, a confiscation can still place independently. Now, my lord, I have two Supreme Court judgments. One, my lord, where they had discussed Andhra Pradesh's Forest Act, and the other one is Madhya Pradesh's Forest Act. But all have that same principle, and the principles are pertinent here, my lord. So, with your lordship's permission, I want to place this judgment. In the very my lord note itself, the beginning bold portion, my lord will see that
Yes.
Andhra Pradesh Forest Act.
Head note.
Yes, my lord. Proceedings under 44 and section 45 are separate and can be initiated simultaneously. There is no conflict between jurisdiction conferred under the two provisions. Provisions of section 42 and 452 and 457 CRPC not applicable where confiscation proceedings taken under Act. So similarly, my lord, here also 450 to 457 subsequently taken over by relevant section of BNS will not be applicable because a complete code under the forest manual has already been provided as per the ratio given by this judgment. Then my lord will come to the next page. First paragraph itself, this was determined. This appeal by special leave raises the question whether the High Court could have stayed under Section 42 of the Code of CRPC the proceedings for confiscation of illicitly felled timber trees by the respondents from the reserve forest in so-and-so district, which were seized under subsection 1 thereof, pending before the divisional forest officer, who is the authorized officer under Section 44 of the Andhra Pradesh Forest Act. So there also, my lord, same system. There is an authorized officer. Then, my lord, will come to the next page, para 4 of the judgment. Para 4, my lord. In order to deal with the question involved, it is necessary to refer to the statutory changes brought about. The Act prior to its amendment by Act 17 of 1976 provided by Section 44 insofar as material as follows. My lord will see this part is almost pari materia with the provisions of Assam Forest Regulations. First part, where reason to believe, my lord will see similar wordings: seizing property, liable for confiscation. Then, my lord, the next page, the court had considered the other provision, which, my lord, can be considered pari materia with Section 51 of our Act. Where a person is convicted of a forest offence, the court sentencing him shall order confiscation to the government of timber or forest produce in respect of which offence was committed so-and-so, other than a cart drawn by animals, vessels, so-and-so used in committing offence. So they also, my lord, had a separate provision where a convicting court can also order confiscation besides the power of the authorized forest officer. Then para 5, my lord. The change in law was brought about with a view to prevent the growing menace of ruthless exploitation of government forests by illicit felling of teak and other valuable forest produce by unscrupulous traders, particularly from the reserve forest, by providing for a machinery for confiscation of illegally felled forest trees of forest produce by forest authorities. So, my lord will see the intent. Why all these states, my lord, have this separate confiscation powers of the forest officers? Because to check this growing menace of exploitation of forest and illegal felling. If my lord, the DFO's prosecution power becomes dependent completely on a trial, my lord, so this rapid, my lord, illegal felling of trees cannot be checked unless there is an independent provision. So that is why, my lord, will see that virtually all states have these kind of independent provisions. And finally, in para 15 of the, in para 14, the scheme of the Act is discussed, madam. Para 14, we find that a later division bench consisting of justices so-and-so, honorable justices, approved of the view expressed by Honorable Justice Jeevan Reddy in so-and-so case. All Supreme Court judgments, my lord.
Okay. Which
And-
paragraph you are reading this time?
14, madam.
For
Para 14 of the judgment.
1-4.
1-4.
Okay. Okay.
And if my lord is at the fourth sentence, fourth line, Muhammad case, and held that the Act contemplates two procedures: one for confiscation of goods forming the subject matter of the offence by the authorized officer under subsection so and so of the Act, and other for trial of the person accused of the offence so committed under section 20 or 29 of the Act. The learned judges held that the Act provides for a special machinery for confiscation of illicitly felled timber or forest produced by the authorized officer under subsection 2A of section 44, enacted in the general public interest to suppress mischief of ruthless exploitation of government forests by illicit felling and removal of teak and other valuable forest produce. They further held that merely because there was an acquittal of the accused in the trial before the magistrate, due to paucity of evidence or otherwise did not necessarily entail in nullifying the order of confiscation of the seized timber or forest produced by the authorized officer. So this is important, my lord. This Honorable Supreme Court has held that even if there is an acquittal, my lord, that would still not lead to an automatic nullification of an order of confiscation, because it is a completely separate and independent power. And finally, in para 15 of the judgment, in the last page, my lord, we'll see that the appeal of the state had succeeded, and where the Honorable High Court of Andhra Pradesh had stayed the proceedings under CRPC, it was set aside, my lord. Then another judgment, my lord, a similar observation, which was relied by this honorable court when the review was rejected, my lord, the petitioner's review.
Review.
Yes, my lord. Where with the one where I just cited in his affidavit, my lord, that was mentioned. Page 65 of the affidavit.
Revision.
Yes.
Revision.
A revision, my lord. Page 65 of the affidavit, my lord, our Honorable High Court had relied on this judgment while dismissing Kalubhai, yes, my lord. So,
forest judgments. These are all forest judgments.
Yes, ma'am.
Forest law judgments.
Yes,
environmental law. Forest wildlife dues.
Similar ratio, my lord. Para 22, if my lord goes to second last page, in view of the foregoing discussions, if my lordship is at para 22. Now this is, my lord, Madhya Pradesh. Earlier we discussed Andhra Pradesh. So my lord will find similar schemes almost virtually in all states.
But who is the originator? I think our regulation is 1891.
Yes, my lord.
But I think 49 came later. I think
49 could have come later, my
it
lord,
has come later.
yes, it could have come later. Yes.
Otherwise, it was drafted by during the British rule.
Yes, my lord.
Amazing, huh? These things are.
That credit must be given to them, my lord.
So I think just let us learn this. I think 49 must have been there. No, 49.
There's no amendment note in the 49. Otherwise,
substituted section 49.
But
okay. It was substituted.
Substituted, ma'am.
Revamped. So it was revamped in 1995.
Yes, ma'am.
1995. Otherwise, the regulation is of 1891. 1891. In the 19th century only. Anyway.
Ultimately, my lord, again in this judgment also, in this Kalo judgment, same, my lord will see para 22 and 23, same, that criminal proceeding and confiscation proceedings are distinct, different and parallel, each having
in this case, criminal proceeding, I think there is an observation in the revision that whether there is a criminal proceeding pending could not be said properly.
No? Yes, that was not submitted, but now for a fact, I have, my lord, produced the records. No pending. Criminal proceeding is pending.
No criminal proceeding.
Only a confiscation proceeding.
Which according to you has attained finality.
Yes, my lord.
Okay, anyway, so no criminal proceeding.
No criminal proceeding.
Anyway, it's an interesting law. Anyway, but whatever has to be decided fairly, you know.
Yes. So, my lord will see this was featured in the rejection order.
That means, I mean, your line of submission is that his vehicle is gone permanently.
Exactly, ma'am. Exactly.
It has been dismissed by Apex Court also.
Exactly.
Okay, I'll see everything, all these things. Because only when it is temporary, then his grievance will have a legitimate, point to be considered.
Exactly.
How can it be kept confiscated, seized indefinitely for 8, 7, 8, 9 years? That cannot be. But anyway, that's this aspect I'll have to see carefully. I'll see it carefully, I assure you. Anyway, that's all.
That's all, my lord.
Any last point? No.
That is my lord, and my lord, an interpretation of this, my lord, will have a bearing on the power of the forest department. So my lord may consider this for future cases also, my lord, because scheme has given
No,
that-
there's no judgment of the our court on this aspect.
on this detail aspect, there is no judgment.
That's
I had
good.
seen.
I have to, in that case, you have to write even more carefully because we think that. So anyway, any reply?
Lordship, just Lordship, my first submission is that, Lordship, in this case, no instruction has been submitted, no affidavit has been submitted.
And one thing just, Mr. Hawk, has come to my mind. When the appeal was dismissed, you filed a revision.
Yes, before this honorable.
Revision, right?
Oh, yes.
And it went up to Supreme Court, it was dismissed.
Yes.
It just struck me, maybe I'm wrong, or maybe I'm right. Since the appeal was dismissed in a, that is the last statutory authority.
Yes.
Appeal,
Last,
appeal. But against that, could it have been a 227 writ petition
Yes.
to examine your
yes,
case,
Lordship.
whether the administrative confiscation is correct or not?
Yes. That Lordship.
point is
Lordship,
there.
Lordship, that's why, Lordship, in this.
So the apex court did not go into that aspect.
Yes.
Did not.
It had come from the High Court
Yes.
as a criminal matter. So it was SLP criminal.
Yes.
So it was dismissed, like many SLPs,
Yes,
it is dismissed.
Oh, yes, yes.
After seeing the prima facie.
Without
No
notice, issuance
But
of notice.
I have exhausted my statutory remedies, and thereafter, as usually we've
Yes.
seen, they come from 227.
Yes.
Lordship, that's why, Lordship, in this High
Because
Court.
it's a court, writ won't lie against a court.
Lordship,
Yes.
Lordship, that's why in this in the High Court judgment, Lordship, it's reflected, Lordship, whatever judgment I have referred, that judgment has not considered as because that was order passed under the writ petitions, but issue was similar. But court is coming to finding, Lordship, that is it is a revision. So that's why
This is a revision.
Lordship.
Which you have annexed now. This is a revision
Lordship.
against against whom you went to the apex court.
Yes, Lordship.
That was a revision.
Lordship. So that's why, Lordship, in this case, Lordship, I have referred some judgment. That judgment has not been considered. A reason has been showing by this Honorable High Court that that case was that case is order passed under the writ petitions. So that's why, Lordship. So, Lordship, my limited submissions, one thing, Lordship.
Yes.
In this case, Lordship, my learned friend is appeared on behalf of this forest department. In this case, no affidavit, no instruction has been submitted, and petitioner is on affidavit. It is informing before this honorable court that he was receiving letter, and letter showing you take your vehicle, and advice has been given that you can obtain an honorable court. We are not given any objections. That's why no instructions, no affidavit, opposition has been filed. But my learned friend,
There are some confusions. But anyway, see, another thing I want to point out, I'll get you.
Lordship, but
paying
my
attention to that.
Lordship, my
complete.
No, Lordship, my submission is that whatever my submission and made by my learned colleague, it is not at all acceptable. As because, Lordship, he is not submitting something in his whether he is submitting something on behalf of the department or on his personal stand, Lordship. He is not personal stand, he is submitting.
I would like to, my lord, reply to this.
Standing counsel. Sometimes see, the thing is, the one thing I just want to point out in the criminal revision, the first line is that judgment and so passed by the learned additional session judge Kasar in misappeal. But if you see the impugned judgment, it is passed by additional district judge.
Additional district judge.
FTC. Additional district. So,
Yes.
One day I have also learned. One day I also didn't. When on the civil side, it is district judge.
Yes.
On the criminal side, it's a session judge. It's an important thing.
Yes.
But the code
But
has
suppose-
that district judge.
But sometimes it
Different.
can be hybrid also.
Yes.
Suppose land grabbing act. If you write district and session judge, that's not wrong.
Lordship.
Because it's a hybrid jurisdiction.
Lordship. That's why, Lordship, it is absolutely correct. I ought to have approached us before this honorable by filing writ petitions.
Occurred to me.
Lordship, that
Now
is
it has gone on that track.
Lordship.
Now
That
it
is
it has been examined also.
Lordship, that is
And
absolutely correct,
My
Lordship.
lord, regarding the contents of my lord, whether I'm making.
Lordship,
Close it, I think.
one more thing, Lordship. My learned friend is point out, Lordship, there is both the proceeding are separate. Confiscating proceeding are as well as the criminal proceeding. It is a correct, Lordship, and whatever judgment has been referred, Lordship, that judgment is not applicable in present case. Yes, because, Lordship, whatever my learned friend is submitting it's against that or whatever judgment also already referred. It's that order has been given against the confiscating proceeding, Lordship. And now, Lordship, that proceeding has been already came into finality. Now, presently, I am not coming against this confiscating procedure, Lordship. So my submission is that very limited, Lordship. And the apex court, this honorable court, why saying this is due to a separate proceeding? As because, Lordship, in CRPC or BNSS, Lordship is very much severe. 50 earlier CRPC 451, and now Lordship 497. During the trial, property seized, and then in the
Yeah, but the thing is that he says, like your one of the last prayers, that residual prayers, that if not anything else, the proceeding may be withdrawn. In which case I hopefully I will get my vehicle back. This is your thinking.
No,
but he says that there's no criminal proceeding.
No, Lordship. That's why. If no criminal proceeding, my vehicle should be released. That's why Lord, section regulation 51 is there. Lordship, in our cases, Lordship, in different stages, Lordship, I think, Lordship, 51 was not there. So that's why in our cases, in our regulations, Lordship, 51 deals.
I'll have to thoroughly go through.
Lordship,
I'll go through. Let me do my homework. We always have an option to ask questions like to be spoken to if there is anything doubt. But broadly, both of you have given extensive materials. This affidavit was essential. Otherwise, it would have been handicapped. It would have been very difficult.
Just Lordship, I would like.
Yes, I do not deny that as a standing counsel, you have the power to make oral submissions also.
Yes, Lordship.
All
Lordship.
cases they do not file. But this I partly agree with learned Mr. Hawk that affidavit because this is not a very simple matter. Yes. There are conflicting things. An affidavit would have helped definitely. It would have further fortified or that your position. But anyway, I've recorded.
Lordship, my submission is very limited, Lordship. That regarding Lordship, that whatever judgment referred, Lordship, just I mentioned that things, Lordship. Regarding whatever judgment is referred, that judgment, Lordship, relating to other state, and in other state, Lordship, so far my understanding, Lordship, there is no law is there relating like 51. 51 saying, Lordship, our regulation is 49 and 51. That is the two is most important. And in this, Lordship, appellate order, it is reflected that, Lordship, 49 orders, it is a temporary in nature. And our High Court's writ petitions orders, Lordship, earlier orders, that is also saying it is a temporary. And final or permanent will becomes when conviction has been will be done as per section or regulation number 51. So herein, that's why whatever judgment is referred, that judgment is in Madhya Pradesh or Andhra Pradesh, and in that state, Lordship, I think 51 is not there. So that's why Honorable Apex Court saying acquittal is not a whatever my submitting in Lordship in the judgment reflected. If a accused has got acquittal, it will not be a hamper or upon the confiscating procedure. That is correct, Lordship. That is correct. I admit it. In that case state, I think, Lordship, that 51 regulations, it's not there. So in our cases, Lordship, if 51 is there, 51 and Lordship will be comes after convictions. So here in case, Lordship, it is fairly submitted, no criminal proceeding is there. So once criminal proceeding is not there, the ultimately in future, Lordship, the convictions part will not come. Once convictions will not.
Law says,
Yeah, law says.
My last point is that as far as it appears that the law says that there is a parallel process where a person, vehicle, property can be confiscated. Confiscation means actually permanent. Suppose somebody challenges this law, then that will be a question to be thought of. It's a very valid question to be thought of. That one can make a provision that forest offense is suspected to have been made until it is adjudicated. Offense is adjudicated by a criminal court, the vehicle can be retained. But whether something can be confiscated permanently without a person being proved guilty in a criminal trial, that would be a separate determination if that provision is challenged. So far, it has not been challenged.
Yes,
so we cannot collaterally go into it.
Lordship, my submission is that in this regard, Lordship, whatever code is made a query, Lordship, in this regard, Lordship, the judgment is there. That judgment is saying, Lordship,
I'll go through again.
Lordship,
I'll go
49
through-
is a temporary.
I'll go through it again.
Okay.
I found another judgment of Justice, my brother Kolita, M.K. Kolita. It is a, I think, long judgment about 49, but I could not get the time to read it. I will read it. That judgment also I'll read it. We could have discussed that, but I did not even have time to take it out. So I'll go through it.
Lordship, just one more thing I would
If you
mention.
search, you'll get that judgment.
Lordship,
It
one
is
more
a recent judgment.
One more thing, Lordship, I would like mention, Lordship. What is 49, Lordship, is when, Lordship, a person, in normal cases, Lordship, 451, that things, when, Lordship, confiscating proceeding will be initiated, then the criminal courts has no power. I think, so for my limited knowledge, Lordship, limited understanding, that is showing. So that when a person, a confiscating proceeding is drawn under 49, then, Lordship, the criminal courts has no power to entertain these petitions, releasing. And whatever releasing, Lordship, it is a interim. When, Lordship, final finding will be comes after convictions, then, Lordship, court has a power. Lordship, otherwise, Lordship, if Lordship in judgment.
Yeah, that is one point of view, and in support of that, you have given this judgment. Justice. Anyway,
Lordship, Lordship, suppose one more thing may be considered, Lordship. That Lordship, one directions and appellate forms, that is still not exhausted, Lordship. That 21 directions, that Lordship, what is the direction has been given, release the vehicle as that direction is still not considered, Lordship, and that's why, Lordship, they have
direction by the appellate court.
Appellate courts, Lordship, and that's why, Lordship, if they for DFO already issued the notice against that directions, Lordship, and in this letter, Lordship, it is mentions, Lordship, everything has mentions, and it means, Lordship, you can take your vehicles.
Okay, I will close this. Mr. Hurd, I hope I brought a good learned counsel for the petitioner and the respondent, Forest Department.
Respondent number 1 state is also
State is also there.
Respondent number 1.
Additional PP for respondent number 1, state prosecution. Full stop. Arguments, the learned counsel's addresses further arguments on the matter. Arguments stand concluded, judgment reserved. Okay. তো ভালকে লগাই থাক